G'day, I'm Michael Tessaro and I prepared this ACCC cheat sheet for June 2026. As you can probably see from the heading there, it's part one, and the reason it's part one is because there's just so much happening in June 2026. I don't think it'll be an hour-long presentation if I try to cover everything. So I'll do half of it, which is a lot of enforcement matters. And for those who don't know what this is all about, it's effectively a summary of everything to do with the ACCC in June 2026, which I think in this particular month, this is very helpful because there was just so much happening in this month. Now, a bit of background for myself. I'm a competition and consumer lawyer, and I've been running my own practice, Tessaro Legal Consulting, for the last 20 or so years. And I help companies, individuals with competition and consumer law problems. I also do some expert consultancy work for various legal publishers, obviously on competition and consumer law. And I have a part-time role on New South Wales Civil Administrative Tribunal as general member. And in that role, I get my chance to do consumer law type complaints. Prior to that, I worked at the ACCC 15 years, a variety of roles in enforcement and mergers. Outline. So what I'll be covering is, it doesn't seem like very much, but it's actually a huge amount. There was a couple of things in relation to the Middle East war, one court case, but a huge amount of enforcement. So that's probably what I'll be spending most time on today. And in the part two, I'll be looking at those other things that are listed there. First one, ACCC issued a press release on the 29th of June talking about what their role would be in terms of monitoring fuel prices, with the fuel excise partly being restored. And this is all, I guess, a bit of a scare campaign by the ACCC, trying to get people or retailers not to, I guess, price gouge, to charge higher prices. And this is arising from the Australian government's decision to extend the temporary cut in the excise, but at a reduced rate. So from the 1st July to the 2nd of August, fuel excise will be lowered from 32 cents to 16 cents per litre. And I guess, as I said in previous presentations, the ACCC only really has power if somebody misrepresents a price increase or colludes. But if somebody engages in perfectly rational behaviour and tries to charge high prices due to being a shortage in fuel, they can't do anything. And probably they shouldn't really, because that's normal economic behaviour. The thing is, ACCC probably would like maybe powers to stop price gouging, but they're not getting them in relation to this area. Rather than getting them in relation to supermarkets, so they receive them in relation to supermarket pricing. Then on the 30th of June 2026, the ACCC announced that it used its powers to issue a class exemption for global supply chain disruptions. So in the last cheat sheet, I talked about this new power that the ACCC received, which was to grant these sort of urgent class exemptions in exceptional circumstances. And they exercised, or they used that power in relation to global supply chains for fuel. So this class exemption applies retrospectively from 23rd of June 26 until the end of the year, and it's a short-term exemption providing legal protection for basically businesses to, I guess, talk about how to service the Australian market in relation to fuel. And these disruptions obviously arising from the Middle East conflict. So this is allowing people who ordinarily wouldn't really want the same room to discuss things and be able to just manage supply so there's no shortages. And I guess the ACCC will have some oversight of what they're doing. It's not just you're allowed to get together in a smoke-filled room. You've sort of got to be accountable for what you're talking about. One court case in June, and that was against a company called RSA Express, which I don't think was a very big company, but effectively ACCC sued them some time ago, and they alleged that they were misrepresenting this particular courses they were running. And so the court found that the company had misled consumers about responsible service of alcohol and white card courses, and there was a couple of breaches that were found. First one was that they were basically representing consumers that they would only pay or be asked to pay for the relevant courses once they passed, and that wasn't true. They actually had to pay before they passed. And it also represented that consumers could undertake relevant courses, obtain a certificate within the same day, and that wasn't true either. You had to spend a lot more time doing the course. So there were a number of customers who were adversely impacted by this, and I think the key thing was people signed up believing these two issues and then realised I can't get it in a day, and they'd pull out the course, and RSA Express would maintain or retain the revenue and the profits from those people pulling out of the course. So there's quite a bit of detriment. This is the first enforcement matter, and it's a takedown notice because Amazon, eBay, Kogan, and Frugo were actually selling products that were banned. And this is just quite remarkable. And I think it's really important because they're going to be more responsible for the way they operate. So basically, on the 2nd of June, ACCC issued takedown requests. So basically saying, stop selling these products because they're illegal to all the 4 companies. And it was toys and games containing potentially deadly small magnets, which obviously kids can swallow. Now, certain separable or loose small high-powered magnets are covered by a permanent ban, which have been around for ages. I think as long as I've been alive, probably, maybe not that long. But it's just quite remarkable these products would get through their systems to get onto the websites and into the market. Interestingly, Kogan, Amazon, and Frugo provided or often provide refunds to customers. The exception there is obviously eBay, and I guess it's because they maybe operate a bit differently. It is a genuine marketplace where third-party sellers sell things. So eBay, maybe they should have come to the party and paid refunds, but it doesn't seem that they were required to. But the other 3 will be paying refunds to anybody who bought the products. And here's some examples of their products. Obviously things will be very attractive to young children, all these little magnets, and you just wonder about the compliance of companies like, I don't know who Frugo is, by the way, but you just wonder about the compliance systems that Amazon and Kogan have in place if they let banned products get onto their website. Next one was about the horticulture code, and 2 companies got taken to, well, pay infringement notice penalties, so pretty significant ones, $99,000 in relation to breach of the horticulture code, which is a pretty complex code and not hard to breach actually, because it's very prescriptive. But in this particular case, Frutico basically traded with grape growers without having a code-compliant horticulture produce agreement in place, which is pretty basic breach, really. You've just got to put these agreements past a lawyer, got to tick all the boxes, make sure they comply. You can't give people or give growers agreements that don't comply. And then Fresh Express failed to provide required gross sale price information to growers in statements about the sale of produce. It's probably a lesser serious breach, or not serious, but less obvious breach, but still a breach. And the interesting thing at the end there, ACCC seems to be getting a bit sick and tired of breaches of the code, because in this particular media release it called for higher penalties. So it's calling for stronger penalties for breaching the code. This is all timed because there's a review of the code being undertaken at the moment. So a pretty good time to ask for bigger penalties and influence the reviewer's recommendations. JB Hi-Fi Group is an interesting one. This is just an administrative undertaking of JB Hi-Fi, and they've agreed to refund $250,000 to a very narrow number of consumers who raised concerns about the company. And effectively, what they're claiming is it was now pricing. So JB Hi-Fi promoted 17 products saying they were discounted from previous price, that were never offered for sale at the higher price or only offered a higher price for a short period. That's a pretty serious breach. Like, I know there's only 200 consumers, 17 products, but I'm sure people have been sued for this before. And here, they seem to have been able to get off entirely with an administrative undertaking, which may be signalling a more pragmatic attitude by the ACCC. It's got a lot of cases and there's a bit of work involved, and maybe we can just quickly deal with them, get a press release out. And as you can see down the bottom, there's sort of maybe the ACCC is trying to justify why it didn't take a harder line with this company. The alleged misleading prices were largely due to system errors or human error. Well, that seems to cover the field. It's either system error or human error. I'm sure every other breach in the past has been due to either system error or human error. Some of which JB Hi-Fi proactively took action on prior to the ACCC investigation, and JB Hi-Fi also cooperated with the ACCC investigation and taken steps to prevent similar issues in the future. JB Hi-Fi are very lucky here because there'd be plenty of guys who've been sued for similar breaches in the past who were first offenders. I can think of half a dozen. JB Hi-Fi is not a first offender. They've had a few problems with ACCC in the past. So lucky for them, but maybe just signalling a more pragmatic approach by the new Enforcement Commission on the good foot. Hi Smile. This is a bit funny, this one actually. ACCC's been on the warpath for a while on social media advertising and endorsements and things like that. So basically, the ACCC issued quite a number of infringement notices, 7 of them, to High Smile in relation to their social media advertising. And they basically posted videos on their social media platform and sort of interviewing random people, random shoppers, and saying, "Have you tried our products?" "Yes." "Are they great?" "Yeah, they're fantastic." Anyway, it turned out that most of these people were actually High Smile employees. Now, I'm not saying that they maybe hadn't used the product, but clearly there's a massive conflict of interest there, and you probably should never use employees to represent your product that way. But I don't know, maybe trying to cut costs, you want to hire professional actors or something. But pretty dumb, really, and they paid the penalty. There was also some other issue and a bit of an add-on part to the case. Uploaded videos to social media showing this gloss stick tooth gloss, which might have created an impression that you use this product and your teeth would be permanently made whiter, but or remove stains permanently. But it had to be continue applying it. So that's a interesting case showing that you've got to be very careful with social media. But it's probably one of these I guess brain fades. It's not the everyday social media breach that you do see. C-Swift. Now, this is an interesting case. Like C-Swift bought a competitor up there in the north. It runs a shipping service, and HMC is very anti this particular merger and tried to oppose it, lost in the tribunal. I think it was probably a mistake by the tribunal. I think it was anti-competitive, and as shown by subsequent events. But here the ACCC caught the company out with various terms in its transport contracts, which initially I thought may be unfair contract terms, but as you can see there, they're concerned that elements of their contracts had anti-competitive provisions that could significantly increase the cost of living in these remote communities. So these guys service remote communities at the top end. And the ACCC got an acknowledgement for them that their conduct may have been anti-competitive, and ACCC decided to get an undertaking from them to amend their terms and not do it again. Now this is a very strange outcome. Like, here's a company that the ACCC thought was going to have market power when they completed the acquisition, and they complete the acquisition after the tribunal gives them the go-ahead, and then they engage in any competitive conduct and they don't get sued. I don't understand that. That's really strange. I'm only assuming maybe the ACCC case wasn't that strong, but really companies with market power who engage in that conduct should get sued. So C-Swift, pulled a Swifty here, somehow avoided getting taken to court. Before I was commenting on the JB Hi-Fi case being maybe a new pragmatism of the ACCC, but I don't think the ACCC would be pragmatic about a breach of anti-competition provisions by a company with market power. So there must be some other underlying narrative here that lets C-Swift get off. Christoffi Investments, the dreaded Ugg boots, and I've been very involved in Ugg boots in the past, and this is Christoffi, pretty well known supplier of products, and it wasn't the traditional thing saying they're made in Australia or anything like that. It's more was now pricing. So they paid infringement notices, 2 infringement notices, for claiming that their Ugg Originals and Ugg Australia Classic boots, and I wonder if they are made in Australia. Not much is made in Australia anymore, so I'm just wondering whether they actually missed the other breach here. Maybe they are made in Australia, but as far as I'm aware, there's virtually nobody making them here anymore. The infringement notice is related to the company advertising their various products at discounted prices and saying, hey, they used to be this price, now they're that price. And the ACCC said that they had not been offered for sale or sold at the higher price claimed in the advertisements. So here's they've been hit with infringement notices as opposed to JB Hi-Fi. I think the ACCC getting a lot of these cases was now pricing, and I think it's a bit like RPM. They sort of said, we could, RPM in the past, ACCC would sue every time, but they'd take undertakings. Here, I think the ACCC is saying, just let's hit them with the infringement notice and move on. The thing is, if you hit them with an 87B undertaking, there's a lot of ongoing work, but it's ongoing work by the company, and why shouldn't a company like Christoffi have a compliance program to make sure this doesn't happen again? So I don't quite understand why you get an infringement notice but not a compliance program as well. Grilled, that's the big case for June, and ACCC commenced proceedings against Grilled for allegedly misleading representations about its 3-day Tuesday donations. And this fits in with the ACCC's, sustainability and green claim priority, which has been there on the list for a couple of years. And here, what has been alleged is that Grilled ran a promotional campaign called Tree Day Tuesday, where they said they'd donate $1 from every burger purchased on a Tuesday towards the planting of trees. I must admit, I've driven past a lot of Grilled and they don't seem to be selling many burgers. I don't know. Maybe there's some that are very busy. But obviously, between January and April, they sold 5 million burgers. So there must be some busier stores than the ones around where I live. But anyway, only 4% of those purchases qualify for a donation. So I think, what's going on here? You said that every burger sold on a Tuesday would result in $1 being donated. So how did only 4% qualify for a donation? And that's because they had all these hidden conditions. For a purchase to qualify for a donation, that satisfies following conditions, and there's a lot. And these weren't very prominently stated. They're probably, if you dug around on their website, you'd find them somewhere, but they weren't apparent. You had to make them on Tuesday. Well, that was pretty apparent. The purchase had to be the main item, being a burger or a salad. Well, that's fair enough. The buyer had to be a member of the Grilled Relish loyalty program. Now, that suddenly limits the number of donations they're going to make significantly. You had to be part of it. Who'd be a loyalty member of a hamburger place? I don't know. Maybe people do that. The purchase had to be dine-in only and not takeaway. Well, that's just online or delivery. Now, that takes out a huge amount nowadays, doesn't it? So many people get. I should be a DoorDash loyalty member because I use it so often. But clearly that takes out a huge number of orders. Dine-in orders had to be placed at front counter. You couldn't use a QR code. Now, that's crazy, isn't it, when you think about it? Because who orders at the front counter? Nobody. So they thought all these ways to sort of say, okay, we'll do this promotion. We'll get a lot of kudos for being very environmentally conscious. We're selling healthy burgers. Now we're environmentally conscious. But we'll make every effort that we can to make sure we're actually paying money to charity or don't make any donations. So this is pretty bad. The buyer had to scan their loyalty program barcode at the counter when ordering. Okay, so that's no good. If you didn't scan it, you didn't get the benefit. The purchase could not be made in conjunction with any other offer, which is probably fair enough. But I don't know if you're making a donation, why it should not be able to be redeemed with another offer. Usually it's if you're going to try and claim 2 separate offers at the same time. That doesn't seem very fair. But here, you want to give money to a worthy cause. Surely, if you're using another offer, that should not be relevant. This is a bad case. I don't know. If I were Grilled, I'd be giving up. Like, unless they pull a rabbit out of a hat. And but yeah, it's just a height of cynicism. And the thing I just don't understand here, and I'm probably burning any bridges I have here to do any work for Grilled in the future, but I don't know why some individual didn't get sued here, because somebody sat down and worked this out, and it seemed to be pretty intentional to me. And this is a classic case where you want an individual to be held accountable for this behaviour, I reckon. WeFlex, so this is part of the ACCC's big campaign with NDIS providers, and they're doing a huge amount of work. Here's an infringement notice that they had to pay. I don't think they're super big. Basically, they're a fitness support company, and they ran a few ads, which again, very misleading. Ad targeted parents and caregivers, encouraging them to get your NDIS child active through personal training service to children and individuals with disabilities. If you have NDIS funding, it's covered. Now, that's not true. In fact, NDIS funding will only cover personal training fitness services if these are approved under a specific plan. So you can't just go off the shelf. I've got an NDIS participant in my family. I'm going to buy this health services. I'm going to get it covered by NDIS. You have to get a plan written out, and it's got to specify the types of services that the NDIS participant needs. And then you go to a company like this and you can claim it. So it's very, very misleading, and people might end up buying this service and trying to claim it back from the NDIS provider and get told you can't claim it back, it's not on your plan. So conceivably, I don't know, but conceivably there could be quite a bit of detriment arising from this behaviour. Next one, Doreen Egg. So this is a free range case. So again, infringement notice. So you can see a bit of a pattern here. ACCC is not suing as many companies, not getting 87Bs, but hitting people with infringement notices. The only problem I think with infringement notices, as I said before, is are they going to have a compliance program to ensure they don't breach the law again in the future? That's really important. I can see half these companies being in front of the ACCC in the future unless they implement a system to identify consumer or even competition law breaches. But anyway, I guess ACCC is maybe trying to get through a backlog quickly, and they're doing a remarkably good job. So here there was representations that the eggs were grown in a particular environment, a free-range environment, and it wasn't true. Doreen sold eggs labelled as free-range despite the hens not having access to an outdoor range required under the relevant information standard, so the free-range egg labelling standard. So basically, the company admitted, that the company sold eggs in cartons displaying Australian Eggs Limited logo, suggesting the business had an affiliation with that organisation when it did not. I think in both cases, the company admitted these breaches. You don't have to admit a breach under infringement notice, but in these cases, in this case, Dorian Egg admitted both. So maybe the ACCC is sort of saying, I don't know, we've got an infringement notice, but we want you to admit the conduct. If you don't admit the conduct, maybe we'll go harder. I don't know. But it's usually a feature of infringement notices that you don't have to admit the breach. You can just pay the money and go about your business. Yagi Proprietary Limited, another company I hadn't heard of. Now, the fact I haven't heard of it doesn't mean it's not really well known. I'm probably a bit out of it when it comes to some of these companies. But basically, it's a health and wellbeing program provider, and the ACCC alleged that the company made a number of misrepresentations. Excuse me. Firstly, they claim they claim the company had a number of unfair contract terms, preventing consumers from cancelling the health program. So that's not misleading, that's just unfair contract term. The second one is that they alleged that Miyagi made false and misleading representations about consumers' rights to cancel or obtain a refund for health and wellness programs, and about its staff's members' professional affiliations. So there's a few breaches there. There might be some consumer guarantee breaches. There might also be some affiliation breaches, expertise breaches. So there seems a bunch of alleged breaches tied up in that particular paragraph. And the interesting thing about this case, and it's the only case so far where the ACCC in a consumer case for as long as I can remember, probably thinking the last one, the property spruiker person, they took Grabisa. That's the last time I remember taking personal, suing an individual personally was probably the last time I remember them doing it. But here they've taken proceedings against Mr. DaCosta, who they claim was involved in the alleged breaches. So he was the head of sales, the head of marketing. I think he was also the boss, but I guess in his role as head of sales and marketing, he oversaw the day-to-day management of the representations made on their various, sites and other ways, like on their website. Maybe also had a role in drafting those contract terms. So interesting that in this particular case they did decide to add an individual, something the ACCC should be doing more of, I think, suing individuals, maybe not for these type of breaches, but for some egregious breaches where there's a lot of cynical behaviour by a company. Speaking of what looks like very cynical behaviour, Armour Group and Force Legal, and I'll be careful here because I think these companies have come out quite strongly saying no breach. But on the 26th of June, the ACCC took proceedings against these two companies, alleging that they were sending out these misleading debt notices, 320,000 of them. And the ACCC has alleged that these two companies made a series of misleading representations. Effectively, it's telling them that they owed money for debts that were probably statute barred. So a lot of these debts were very old, and they're saying that they couldn't enforce it. And they're doing it for many years. They're saying that, send them to consumers by email, letter or text over more than 3.5 years about debts they allegedly owed. So there's a strong element of harassment there. If you're pursuing somebody for 3.5 years, that's bordering on harassment. The ACCC alleged notices from ARMA represented to affected consumers that the debt that was due, that required payment, when in fact the debt was either no longer outstanding, being paid, or was maybe it had been written off, or was past the statute of limitation period. That's pretty serious, particularly if Force Legal, that's a law firm, if they're making representation. So I guess I'll keep going. It also alleged that Force Legal sent letters containing misrepresentations about the steps it would take to escalate matters. So You don't pay, we're going to take you to court. Maybe that wasn't really going to happen. It's just an empty threat. And the potential consequences of non-payment. There's a bit more. So here's some examples of the stuff they were saying to people. Force Legal was instructed to start legal action to force a debt when, in fact, they'd ever received such instructions. Now, just thinking through that one, if you're a lawyer and you're working for Force Legal and you're writing a letter saying that and it's not true, then I think you can kiss your practice certificate goodbye. So this is a big case for Force Legal. If the ACCC is successful, not only will they get fined quite a bit of dough, but I think a few lawyers who are working for Force Legal might be looking for a different job because that'd be very serious if established. Force Legal was an independent of Armour when in fact it was a related body corporate. So there's a parent company that owns both these. So they're trying to create this idea that, Armour sent it to Force and now we're pursuing it. Maybe not the most serious misrepresentation, but obviously creating this sort of strong impression that this legal process has been um, mobilised against you and you've really got to give us the money or else. Consumers might have payments deducted from their pay without a court hearing. In fact, it only occur if a court granted a garnishing order. Things like that. So misleading people about legal consequences. Consumers have to pay all legal costs and interest when in fact no automatic entitlement to recover such costs. And other than WA. WA is a real problem, you know. I've had a couple of cases over there where people tried to enforce their rights and I told them, you better give up because realistically you lose, you've got to pay costs and it's not worth it. But so that's a real anomaly in WA. But in most other jurisdictions, you get only minimal costs um, in any cases. It's all capped. So this is very serious for everybody. I know that Armour and Force have said they're going to fight it. Again, it's the kind of case where I think if you're going to take a case like this in your ACCC, you had an individual in there because somebody has been behind the whole architecture of this behaviour. And I had a case many years ago. It was going to be against OneTel, and they'd set up a debt collection company a bit similar to this. And I remember they named it after, I can't remember the exact name, but it was Smith, Wesson and something else. And I said, why did you name it that? And they said, well, we just decided that name. And I said, you've named it after the names of three handguns. They'd actually done that. They'd actually called the company with the names of three handguns. And then that was a debt collection company. I was getting very ready to sue them for that behaviour. And then they went broke. So I never got to run the case. But that's the kind of thing. I was trying to scare poor people with debts that can't afford to pay them. By intimidating tactics. That's what it looks like here. That's what OneTel were trying to do back there in a very blunt manner. And the other thing that's really apparent here is if you're a lawyer at Force Legal and any of these breaches are established, I guarantee there's going to be a referral to the relevant disciplinary body in each state. And I think you're going to be very lucky to keep your practicing certificate if you've engaged in this conduct. HSK United. So this is an online retailer, operates a bunch of websites, pain-free Aussies, modern Aussies. I don't think it's a super big company by the sounds of it. And they paid some infringement notices. And effectively they were, again, engaging in the dreaded strike-through pricing. So it's a bit of a rash of strike-through pricing cases at the moment. Basically crossed out, replaced with lower price. However, the products have not been sold at the high strike-through price since at least January 25. So here you're talking about 12 months, that they hadn't sold it at the higher price. So I guess it comes all back to this Coles case. What does that mean? I guess that Coles case has sort of said 12 weeks, although the judge was at pains saying, hey, this applies to this fact scenario. It's not a broader application. But I said in the previous cheat sheet that industries responded to the Coles case saying 12 weeks. It's got to be 12 weeks. ACCC also issued them with 2 infringement notices over alleged misleading statements in return to the return policy. And this is the kind of stuff that people used to get sued for, Was now pricing. I've had clients who got sued for this. Was now pricing and misrepresenting returns policies, or at least an 87B. So again, it's just suggesting ACCC is maybe trying to clear the decks, become a bit more pragmatic. I don't know, but they are resolving a lot of matters through infringement notices. And so here they said that basically clearance items and items purchased with store credits were non-refundable, when in fact the consumer guarantees apply to all those goods if they're faulty. So that's a misrepresentation. And there's the ads that they were sort of running. You see the cross through the 72 and it's 36 on sale. Well, that wasn't accurate. Okay. I don't know if I'd like to be the person, the model who appears in this media release. Would you like that? I don't know. But anyway, so I guess you know so about the matter. eDreams. So this is a Spanish company, Vacaciones eDreams SL, and they were hit with 3 infringement notices for making misleading pricing claims. This is an interesting one. It fits into the ACCC's campaign, or I guess future campaign or current campaign about subscription-based memberships. Actually, it's part of the priorities, and it's also something that's going to be very much the focus of the unfair trading practices laws when they come in next year. And they claim that they failed to prominently display the total cost of annual subscription. So 2 breaches alleged. I think I can say 2 breaches established because eDreams admitted both breaches. The first one, the subscription-based membership pricing, and the second one, total cost. So eDreams admitted that from 21 to 25, it told consumers check out that they could get this Prime subscription for a free introductory 15 days and they wouldn't have to pay any money. But what eDreams were concerned about is people getting the Prime subscription once, cancelling, and then doing it again, right? And that's what a lot of people do in various subscriptions. They keep signing up for free subscriptions. So what eDreams said, well, you can sign up for a Prime subscription service for free, but if we go back in our records and we check and you had it previously, too bad. We're going to charge you. And that's the problem. If they just sort of said you had it previously, you can't have it twice, and they cancelled it, that'd be all right. But then they just started charging people. They checked the eligibility of people for the free offer, and then they just charged them. That was pretty silly, really. And then they also admitted that they were publishing the monthly prices for annual subscription and didn't say the full price. So you basically had to sign up for 12 months, and you're getting charged. You're committed to the full 12 months, but you're only getting told the monthly charge. So pretty straightforward breaches, and they've entered undertaking. They've got to provide refunds, and there's an 87B undertaking, so they've got to set up a compliance program. Hopefully they've learned from this particular thing. Okay, so commentary, Express Online case, probably not the biggest case of the century, but an interesting case, and showing that they're conscious of all different facets of the economy. His RSA courses being offered on a particular misleading basis. Takedown notices. Now, this don't happen very often because most companies don't sell banned products, and particularly big companies like Amazon and Kogan do terrible stuff. And I don't know what their compliance programs are like, but surely they've got to have a system where they don't sell bad products. They're very dangerous. Horticulture code breaches. The main thing there is ACCC seems to think the penalties aren't high enough, need to be increased, and they've pitched that at a really good time because let's face it, there's a review and they've got a good chance of getting their wishes. High Smile, I guess, probably not a real case to learn from. It's pretty dumb, really, to be using your own employees as and claim they're bona fide shoppers. But I guess it highlights ACCC's very vigilance on social media advertising notifications. C-Swift, don't understand that case at all. ACCC didn't want the merger to go ahead, it went ahead, concerned C-Swift had market power, appeared to use its market power almost immediately on the merger getting through after the tribunal gave it the tick. Then they enter into agreements that are anti-competitive and they don't get sued. Like, if you're the ACCC, you want to maybe send through some consumer ones quickly, get rid of them, infringement notices. And when a competition case comes along, you've got to run it, don't you? You can't. They're not that common, and you've just got to run it. So I think there must have been some other problem here, maybe, with the case. Maybe their evidence wasn't great or something. But you see Swift, I shouldn't say pulled a Swifty, but they definitely dodged the outcome that you would expect. If you're a company with market power and you're engaging in anti-competitive conduct, 46, you get sued, don't you? Anyway, Grill, that's a big case. And again, a case which I think, if I was Grilled, I'd give up immediately. Let's face it, there's no individuals being sued, so it's pay a penalty, move on. Very cynical breach. ACCC would be after a lot of dough there, I think, a lot of money. So maybe that's the main reason Grill might not tap them out, as they say, because they're worried about a very big fine. But it sounds like a very cynical misrepresentation. It's right in the ACCC's priority areas, environmental, sustainability stuff. And it's just so cynical in the way they've excluded. 96% of the burgers bought did not result in a donation. That's very bad stuff. Miyagi, the company itself, though, maybe they're really big, I don't know. But the key thing here is you've got the ACCC suing an individual for personal or accessorial liability, and that's pretty rare in non-competition cases. Consumer cases very rarely doing it. I think the ACCC should do that more often. Like, where an individual has been involved, you've got to send the message that the company's going to be liable, but so are individuals. And here they decide to sue an individual who they believe was involved, I don't know, either in the misreps or the unfair contracts or both, I don't know. Armour Group and Force Legal, very serious case. And I know, I just note again, Armour Group and Force Legal have, I think, said publicly they're going to fight it vigorously, which a lot of people do say that. Maybe they are, maybe they're not. But the key thing there, it seems to be very cynical. And if you're a lawyer who is involved in this conduct for Force Legal and it's established, I think you can have trouble with your professional standards bodies in your respective states. It's for lawyers to be misrepresenting legal processes, even that debts are recoverable when they're not, that you can take money from people's wages without a garnishee order. That's all probably professional misconduct. So I think there could be more pain for some of the lawyers working at Force Legal. Again, I don't understand why some individuals weren't added there. I think, just do the work, get some details about individual involvement, sue some individuals. So it makes the case harder. I think it sends a stronger message too. Like, so many fines, people see them and they go, okay, but it's when individuals are held accountable that I think people really sit up in boardrooms. eDreams, again, and you've seen a few of these infringement notices, companies have given admissions. And so I'm just wondering whether the ACCC saying maybe in a negotiation you can have an infringement notice, but you've got to admit the breach. If you don't admit the breach, we'll sue you. So I guess given that option, I'd take the offer and admit it. That seems to be a trend I've seen. I've seen in these cases a trend of infringement notices with admissions. The big concern I've got on infringement notices, if you're going to get infringement notice, get a commitment to enter a compliance program. So you see in eDreams, they got a compliance program. Important, they're a big provider, they're very engaged in the market. They need a program to make sure they don't breach the law again, particularly they're a foreign-based company, maybe not super familiar with Australian laws, I don't know. But if you're going to get infringement notice and you're with ACCC, you can do two things. You can say, we want an admission, and we want you to set up a compliance program. That's really important. Because you don't want people coming back all the time. Like JB Hi-Fi, how many times has JB Hi-Fi had trouble with ACCC? Heaps of times. And you just don't want company coming back. Compliance programs ordinarily the best way to stop somebody coming back. Not guaranteed, but it's the theory is if you've got a compliance program, the chances of repeat offending is significantly reduced. Okay, so that's part one. As you can see, a lot there. I went 40 minutes just doing part one. Part two won't be as long. But if you have any questions about any of this, feel free to give me a call or drop me an email. Bye-bye.